Indianapolis, January 27, 1992, Monday morning. The trial of Mike Tyson begins. The Marion County Superior Court is overflowing. Press from around the world. Cameras positioned outside. Security everywhere. Inside courtroom 4, the atmosphere is tense, electric, historic. This isn't just another celebrity trial. This is Mike Tyson, the baddest man on the planet. Undefeated in public perception even after losing to Buster Douglas. Still the most recognizable athlete in boxing. Still a cultural icon. Still someone people assume is untouchable. Sitting at the defense table is Vincent L. Fuller, 58 years old, partner at Williams & Connolly, one of the most prestigious law firms in Washington, D.C. Fuller isn't just any attorney, he's a legend. Defended John Hinckley Jr., the man who shot President Reagan and got him acquitted by reason of insanity. Defended corporate executives, politicians, powerful people accused of serious crimes. His record is extraordinary. His reputation impeccable. When Mike Tyson hired him, everyone assumed it was over. Assumed Fuller would destroy the prosecution. Assumed his cross-examination skills, his courtroom presence, his decades of experience would dismantle any case against Tyson. Tyson's team had been saying it for weeks. Nothing will happen. This case will fall apart. Desiree Washington's story won't hold up under scrutiny. The jury will see through it. Mike will walk away vindicated. They had reason for confidence. Fuller's strategy was clear from the beginning. Attack Desiree Washington's credibility. Suggest she knew what she was getting into when she went to Tyson's hotel room at 2 in the morning. Suggest the sex was consensual. Suggest she only cried rape afterward when she realized she could get money and attention from accusing someone famous. It's a standard defense strategy in rape cases. Put the victim on trial. Make the jury doubt her. Make them think she's lying. Fuller had used variations of this approach successfully for decades. No reason to think it wouldn't work now. The prosecution's case was strong, but not overwhelming. Desiree Washington's testimony about what happened in room 606. Medical evidence showing internal injuries consistent with forced penetration. Testimony from her roommate about her emotional state immediately after. Testimony from Tyson's driver about how she looked leaving the hotel. Expert testimony about rape trauma syndrome. But no video, no recording, no witnesses to the actual assault. Just Desiree's word against Mike Tyson's word. In that situation, the defense usually has the advantage. Reasonable doubt is a powerful tool. Fuller just needed to create enough questions about Desiree's account to give the jury room to acquit. That was the plan. The first week of trial went reasonably well for the defense. The prosecution presented their witnesses. Desiree testified for hours, described the assault in detail, stayed consistent under cross-examination. But Fuller landed some points. Got her to admit she'd gone to Tyson's hotel room willingly. Got her to admit she didn't scream for help. Got her to admit she didn't immediately run to police. Small victories. Seeds of doubt planted in the jury's mind. By the end of week 1, legal analysts were split. Some thought the prosecution had established their case effectively. Others thought Fuller had created enough reasonable doubt to win. Nobody predicted what was about to happen. Week 2 began on February 3rd. Monday. The prosecution rested their case. Now it was the defense's turn. Time for Fuller to present his version of events. Time to call witnesses who would support Tyson's claim of innocence. Time to systematically destroy the prosecution's narrative. Fuller's first major witness was a surprise. Dr. Thomas Richardson, a physician who examined Desiree Washington 2 days after the alleged assault. Not the doctor who did the original rape kit examination. A different doctor. Someone Desiree had seen for a follow-up appointment. Fuller called Richardson to testify about that examination. The strategy was clear. Richardson would say Desiree seemed fine. No signs of trauma, no emotional distress, no physical injuries beyond minor abrasions. This would contradict the prosecution's narrative of a violent assault. Richardson took the stand. Fuller began his direct examination. Asked Richardson to describe his examination of Desiree Washington on July 21, 1991. Richardson said she came in complaining of vaginal pain. He performed an examination, Found some minor abrasions. Nothing serious. Nothing that couldn't happen during consensual sex. Fuller asked about Desiree's emotional state. Richardson said she seemed calm, composed. Not what he'd expect from a recent rape victim. Fuller smiled. This was going exactly as planned. Then the prosecution's turn came. Barbara Trathen, the assistant prosecutor, stood for cross-examination. She asked Richardson a simple question. Did you review the medical records from Desiree Washington's examination at Methodist Hospital on July 19th, the examination performed immediately after the alleged assault? Richardson said no. He hadn't reviewed those records before examining Desiree. Trathen asked why not. Richardson said it wasn't provided to him. He was doing a follow-up examination. Didn't think it was necessary. Trathen then entered into evidence the original rape kit examination report from Methodist Hospital. Asked Richardson to read it. The report detailed significant internal trauma, tearing, bruising, injuries consistent with forceful penetration, injuries that would take days to heal. Richardson read it. His face changed. Trathen asked if these injuries were consistent with consensual sex. Richardson hesitated, said they could be, but they were more consistent with force being used. Trathen asked if Richardson's examination 2 days later would naturally show less trauma than the immediate examination. Richardson said yes. Injuries heal. What seemed minor on day 3 would have been much worse on day 1. Trathen asked if Richardson's testimony that Desiree seemed fine was therefore misleading. Richardson said quietly that without the context of the original examination, his testimony was incomplete. Fuller had just been destroyed by his own witness. The jury saw it. The press saw it. Everyone in the courtroom saw it. A defense witness who was supposed to discredit the prosecution's medical evidence had instead confirmed it. Fuller tried to recover on redirect examination. Asked Richardson if the injuries could still have occurred during rough but consensual sex. Richardson said technically possible but unlikely given the severity. The damage was done. Fuller's next witness was supposed to be stronger, a character witness for Tyson, someone who knew him well, could testify to his gentle nature, his respect for women, his inability to commit such a crime. The witness was a woman who dated Tyson briefly. She testified that Tyson was always respectful with her, always took no for an answer, never aggressive, never violent, a perfect gentleman. The prosecution's cross-examination was brief. Asked if she'd ever been alone with Tyson in a hotel room at 2 a.m. She said no. Asked if she'd ever rejected Tyson's sexual advances. She said no, they'd had a consensual relationship. Asked if she could therefore know how Tyson would react to being told no in a private setting. She said she supposed not. Another witness neutralized. Fuller brought several more character witnesses. People who said Tyson was kind, generous, incapable of rape. The prosecution asked each one the same questions. Were you there on July 19th? Did you see what happened in room 606? Can you say with certainty what Mike Tyson would or wouldn't do in private? Every answer was no. The character witnesses were worthless. Then Fuller made his biggest mistake. He called Mike Tyson's limousine driver, Virginia Foster, as a defense witness. Foster had driven Tyson and Desiree Washington the night of the assault. The defense wanted her to testify that Desiree seemed fine when she got in the car to go to Tyson's hotel, that she was laughing, flirting, clearly willing. Foster testified that Desiree seemed normal when they drove to the Canterbury Hotel, seemed excited to be with Mike Tyson, seemed like she knew what was happening. Fuller thought this was helpful, thought it showed Desiree went to the hotel room voluntarily and willingly. The prosecution's cross-examination was devastating. They asked Foster about the return trip, when Desiree left Tyson's hotel room and Foster drove her back to her hotel. Foster's demeanor changed. She said Desiree looked completely different, disheveled, crying, wouldn't make eye contact, sat as far from Foster as possible in the back seat. The prosecutor asked Foster to describe Desiree's emotional state. Foster said she looked traumatized, looked like something terrible had happened. The prosecutor asked if Foster had seen this kind of change in someone before. Foster said yes. She'd been a driver for years. She knew what women looked like after being assaulted. This was that. The prosecutor asked why Foster was testifying for the defense if she believed Desiree had been assaulted. Foster said quietly that she was subpoenaed. had to testify, was just answering questions honestly. Fuller had called a witness who confirmed the prosecution's entire case, confirmed that something happened in that hotel room that transformed Desiree Washington from excited and happy to traumatized and broken. The jury was leaning forward, taking notes. This was the most damaging testimony yet. Fuller tried to salvage it on redirect. Asked Foster if Desiree could have just been upset that Tyson didn't want a relationship, that she'd hoped for more than a one-night encounter. Foster said firmly that wasn't the kind of upset she saw. This was trauma. This was assault. This was a woman who'd been violated. Fuller had no more questions. By the end of week 2, Fuller's defense had collapsed. Every witness had either been neutralized or had actively helped the prosecution. The defense that was supposed to create reasonable doubt had instead eliminated it. The whispers in the courthouse were brutal. How had Vincent Fuller, one of the greatest defense attorneys in America, made such catastrophic errors? How had he called witnesses who destroyed his own case? How had he misjudged so completely? The answer became clear in the days after the trial. Fuller had relied on assumptions. Assumed that attacking the victim would work like it usually did. Assumed that character witnesses would sway the jury. Assumed that medical evidence could be explained away. Assumed that reasonable doubt was easy to create. He'd assumed wrong. This case was different. Desiree Washington was too credible, too consistent, too obviously traumatized. The medical evidence was too clear. The corroborating testimony too strong. Fuller's standard playbook didn't work because the facts didn't support it. On February 10, 1992, the jury returned their verdict after 9 hours of deliberation. Guilty on all 3 counts: rape, 2 counts of criminal deviant conduct. Mike Tyson sat motionless. Vincent Fuller looked stunned. The courtroom erupted. Outside, reporters broadcast the verdict live. Around the world, people watched in shock. Mike Tyson, the untouchable champion, convicted. His legal team that had promised nothing would happen had delivered a disaster. In the weeks after, legal experts dissected Fuller's mistakes, called them historic blunders, said he'd taken a winnable case and thrown it away, said he'd called witnesses without properly preparing them, said he'd relied on character assassination instead of addressing the actual evidence, said he'd underestimated the prosecution and overestimated his own abilities. Fuller's reputation took a serious hit. He'd been hired because he was supposed to be the best. He'd lost in spectacular fashion. Lost not because the case was unwinnable, but because he'd made critical strategic errors that backfired publicly and dramatically. Tyson fired Fuller after the conviction, hired new attorneys for the appeals process. Those appeals failed. Tyson served 3 years in prison. When he was released in 1995, he never spoke positively about Fuller, never thanked him, never defended his work. Years later, in interviews, legal analysts still point to the Tyson trial as a cautionary tale, a reminder that reputation doesn't guarantee results, that assuming victory leads to defeat, that underestimating your opponent is fatal, that sometimes the most famous attorney in the room is also the most overconfident. Vincent Fuller had walked into that Indianapolis courtroom expecting to dominate, expected to win easily, expected his reputation and experience to carry the day. Instead, his defense backfired so completely, so publicly, so devastatingly, that it became a turning point in legal history. Mike Tyson's team had said nothing would happen. They were right in a way. Nothing happened for Mike Tyson. No acquittal, no vindication, no triumphant return to boxing without consequence. Instead, conviction, prison, a legacy permanently damaged, all because the attorney who was supposed to save him made mistakes that anyone watching could see. That's what happens when confidence becomes arrogance, when reputation replaces preparation, when assumptions replace evidence. Vincent Fuller learned that lesson in the most public way possible. So did Mike Tyson. So did everyone watching who thought fame and money and the best lawyers could overcome truth.